I was on the Bigger Pockets forum and I noticed that Kevin, a dentist, was looking for some help. He has 10 single-family homes and 20 parcels of land he's looking to protect. But the lawyers he talked to gave him some terrible advice. So I'm going to point out that bad advice and I'm going to walk you through what I think Kevin should do to protect his dental practice, his properties, and his family. So let's look at what Kevin said. I own 10 single-family homes and 20 parcels of land. I am a dentist and make a good chunk from that business yearly. I want to protect my assets and have spoken to a local lawyer, PCS, Anderson and NCH. A local asset protection attorney just wanted me to place all my assets in a Florida LLC for $5,000. Cost range from $5,000 to $10,000. When I spoke to these companies, I felt very confused and wondered if I was getting oversold or just naive at this. Am I being cheap? What are your thoughts? PCS offered the following idea. Revocable Living Trust, which owns a Wyoming LLC, which owns about 3 Florida LLCs. Total cost, around $5,000. NCH offered the following idea. Revocable Living Trust, which owns a Wyoming LLC for property management, S-Corp election, another Wyoming LLC for stock trading, and another Wyoming LLC disregarded that holds the assets. The latter LLC will own all 10 of the income-producing single-family homes. Then they advised I put the income-producing single-family homes in their own revocable land trust. All this would cost about $10,000. The other 20 vacant parcels would be owned by the revocable living trust. I personally feel like this is way too complicated, but on the upside, I can use one bank account for all the rentals, which would make my life so much easier. His local attorney suggested he places all of his properties into a single Florida LLC. Really? Listen. Can you put all of your rental properties and assets into a single LLC? You can, but you shouldn't. Think about it for a minute. You're putting all of your eggs in one basket. What if you put all 10 single-family homes that are income-producing properties into a single Florida LLC and one bad liability event takes place at one of those properties? Well, as an attacking attorney, the attacking attorney is going to sue the entire LLC, and that Florida LLC will completely go into lockdown, and potentially, if you lose that lawsuit, Kevin could stand to lose all 10 of his single-family homes, and all of that equity could be liquidated at the sale, the forced sale, in the event of a loss. Now, why would you do that? One of the better ways to do this is to consider single-family home per LLC. You isolate the property, you segregate the risk. But by no means, don't put all of your eggs in one basket. What about PCS? They suggested that Kevin set up a revocable living trust, a Wyoming LLC holding company, and 3 separate Florida LLCs that he groups all 10 of his properties amongst those LLCs. Now, although we're moving in the right direction here, it's creating more risk than is necessary for Kevin's portfolio, because now, once again, he's having to put 3 to 4 properties into a single LLC, and like we talked about a minute ago, you could run into a serious problem if you lose a lawsuit. You could lose up to 3 or 4 of those properties. And these attorneys forgot one important element. In Florida, you have something known as the dock stamps fee. And if you don't take it into account, you can end up spending tens of thousands of dollars. And this plan suggested did not take that into account. Finally, what about NCH's suggestion? If you remember what they said, they advised him to set up a living trust that owns a Wyoming LLC for property management, and then to set up another Wyoming LLC for stock trading activity, and another Wyoming LLC to hold his 10 income-producing single-family homes. And then on top of that, they mentioned that all 10 properties should be transferred through a land trust. The remaining 20 parcels of land would then be owned by the revocable living trust. Wow, how complicated is that? First of all, a couple of things to be aware of. We're moving in the right direction here, and we're now talking about the concept of using a land trust to help avoid some consequences. The problem with this approach is when he mentions setting up a Wyoming LLC holding company and then moving all 10 single-family homes into one LLC in Wyoming, here's the rule. You cannot borrow another state's beneficial laws for the LLC you move your property into. So the problem with this approach is you're not going to be able to get the benefit of Wyoming's law for a property located in another state. So as a result of that, you're going to run into unnecessary LLCs being set up, Look at all these Wyoming LLCs that are being set up, and you're not exactly getting all the protection you think you are. Poor Kevin. What is he to do? Should asset protection really be this confusing? No. Let's simplify things and let's lay out best practices so that Kevin can sleep well at night knowing his assets are protected. First things first, Kevin needs to get these high-risk assets out of his personal name and into an LLC. The problem with this? There are normally three main challenges when you're trying to get an asset out of your personal name, like rental property, and into an LLC. 2/3 of states all over the country have what's known as a transfer tax. What is a transfer tax? It's essentially a tax charged upon you by the state if you move ownership of property from one person to another. So technically, in many states, if you set up an LLC and you transfer ownership from your personal name into an LLC, there's been an ownership of transfer. You no longer own the asset, but you control the asset. So as a result of that, if you don't have a strategy in place, the government can tax you. And that can range anywhere from 0.2% all the way up to 3% of the value of the property. The next challenge for being able to move a rental property from your personal name into an LLC is what is known as the due on sale clause. The due on sale clause essentially means if you move property from your personal name into an LLC and you have a mortgage on the property, technically you've breached your contract with that lender if you moved it over without their consent. You say, now wait a minute, I'm still in control of everything. And that's true. Now, there are exceptions to this if you have an FHA, Fannie, or Freddie product, but other than that, if you move these over, be aware, technically, if you've got a very low interest rate, say sub 3.5%, and now interest rates might be at 8%, you could be looking at a situation where your lender could come back and call your note due and accelerate, requiring you to either pay it all up front or at current market rate. Finally, the next challenge in being able to move assets from your personal name into an LLC doesn't happen on the front end, but it happens on the back end later on. Let's say you're taking out a conventional loan, which most people do, to buy their first short-term rental or their first rental property like Kevin. If you were to do this and you were to move the property into an LLC and then you wanted to refinance later, that's not really going to be an option for you. Why? Because when you look to refinance, you cannot refinance a conventional mortgage in an LLC. If you do that, first of all, the lender's going to force you to pull it out because underwriting will not allow it. And then once you do pull it out, if you're in a state like Florida or 2/3 of other states that have a real estate transfer tax, you'll be taxed for pulling it out. And then after you finish the refi, they're going to tax you when you put it back in. You'll get double taxed for refinancing. But the good news is Kevin can avoid all of these consequences by employing the Florida Land Trust. What is a land trust? A land trust is a simple grantor trust that holds property. Essentially, there is a grantor, there is a trustee, and then there is a beneficiary. The landholder, the actual owner of the property, would be the beneficiary of the property, and then your attorney or a third party could be the trustee, only as a nominee trustee that would immediately resign as soon as title to the property is transferred. So let me explain how it works. In this situation, Kevin could move each of his single-family homes into an individual land trust. Then he can assign his beneficial interest. What is a beneficial interest? The beneficial interest is anything worth suing, anything that has value. And as that beneficiary, Kevin can assign his beneficial interest into now a Florida LLC. So he can not only obtain asset protection that way, but he's able to avoid the dock stamps fee, that real estate transfer tax we talked about. He can help avoid that because the property never actually transferred into the LLC. If Kevin does this for each of his properties, what has he achieved? Number one, he doesn't have to pay that ridiculous dock stamps fee, which will save him tens of thousands of dollars in an effort to protect his assets. Number two, he will not even have to worry about the due on sale clause because under the 1982 federal law, the Garden State Germain Act, if you move property from your personal name into an LLC and you use a land trust to do so, you don't have to worry about your note being called due. And finally, he won't have to worry about the refinancing problem. Why? Because here's how it works. Let's say later on, Kevin decides he wants to refinance his properties. The great thing is, because he had originally assigned his beneficial interest in the property, in the land trust, to that LLC, here's the beautiful thing. He can now reassign that interest back into the land trust. He can then change the trust language from a land trust to a living trust. It's known as restating the trust. He can then complete the refinancing with his lender, and once he's done, he can change it back to a land trust and reassign his beneficial interest back into the LLC, avoiding the tax issue, avoiding and completely maintaining all of it privately with anonymity. These are the type of tools that Kevin needed to use, and so that he doesn't hold himself up as he continues his investments. This is a great start to asset protection, but there are still two major problems. Number one, Kevin has no privacy. What do we mean by this? Well, under Florida law, in an LLC, these properties are separated from ownership from his control, which is a great thing. But if an attacking attorney goes to the Secretary of State and does a search, they're going to find Kevin's name listed as the member on that LLC. And having been a former attacking attorney on this issue, what we would do is then actually sue Kevin as a member and his LLC. And if we can show that at any point he commingled personal and business funds, failed to follow the corporate formalities of what's required in Florida, or a host of other issues, we may be able to do what's called pierce the veil. And if we can pierce that veil, we can hold Kevin personally liable as a member for all the actions of his LLC. That's harder to do if I can't find him and he has privacy. But in addition to not having any privacy, Kevin also does not have charging order protection. What is a charging order? A charging order basically means that if an attacking attorney brings a lawsuit against a Florida LLC and they win their lawsuit, they could go in, demand that the court sell the property, allow them to sell that forced sale of the property in order to be able to obtain all of the equity within that LLC. And as a result of that, you lose your asset. You would love to have charging order protection, which would allow you to be able to avoid that consequence. When you have charging order protection, no one can make you sell, even if you lose. And that he does not have in Florida. So now Kevin could create a Wyoming LLC holding company that is the single member owner of each of his underlying LLCs. And here's how Kevin would be protected from an attacking attorney. Let's say that each of his single member LLCs that owns each of his rental properties is now owned by a Wyoming LLC holding company. Same lawsuit scenario, the attacking attorney would first start in Florida. And when they go to Florida, the first thing they're going to find is the Secretary of State's going to inform them the single member owner is in Wyoming because it's a Wyoming LLC. That attorney will now have to go to the Secretary of State in Wyoming, and when they get there, they're going to find out, stop right there. In Wyoming, there are special privacy laws where they will not disclose the names of the members. Privacy achieved. But secondly, that attacking attorney is going to also realize that because the Wyoming LLC is the holding company owner of all the base layer LLCs in Florida, now they also have charging order protection. So even if one of his properties is sued in Florida and he were to lose, he could not be forced to sell. He could literally continue to rent out his property, pay all of his expenses. The only thing he cannot do is take an owner's distribution. You say, well, why does this matter? Because at the end of the day, attorneys get paid on a contingency fee basis. And if they can't make Kevin sell, he becomes a very unattractive target, and good asset protection will push that lawyer down to good insurance. As a result, Kevin has protection. Remember, a big goal of asset protection is to push the lawyer down to the insurance settlement and not towards your personal assets. But there's one final problem with this strategy, and it's a lack of flexibility if you get sued. What do we mean by this? Well, if he uses the Wyoming LLC holding company, and the more properties he places under ownership of that Wyoming LLC holding company, if one of them gets sued, he's not able to move very many assets. He cannot move any assets out of the Wyoming LLC, and he has to be careful how he moves his money around. Why? Because of the concept known as a fraudulent transfer. Under the court's analysis, if there's a lawsuit, the court will be looking to see a fraudulent transfer analysis. Was Kevin trying to move any of these assets or monies around to avoid the lawsuit? As a result of that, sometimes if you have a growing portfolio, using this strategy can create some post-lawsuit paranoia when you manage your portfolio. And the solution to that problem for Kevin is the Arizona Limited Partnership. And if you'd like to learn more about this strategy and how it can help you with a growing portfolio, check out this video and I'll see you over there.